So good morning, good afternoon, and good evening, everyone. Thanks for being here at the NNU Immigration hosted webinar titled The First 100 Days of the Trump Administration. My name is Nita Nicole Upadhyay. I'm the managing partner at NNU Immigration, and I'm joined today by my esteemed colleagues, Naomi Hanrahan Soar, partner at Lewis Silkin, who will be sharing her insights on UK immigration today. Pavan Dhillon, partner at Dhillon Immigration and our Canadian immigration expert. Chris McLemore of McLemore Konchnik, who's our top London-based US tax lawyer. And Michelle Bush of MBM Commercial, who will share insights on employment law. April 30th, 2025 marks President Trump's 100th day back in office. In just over 3 months, we've seen a wave of policy shifts that have already reshaped the immigration, tax, legal, and business landscapes in the United States and beyond. With ongoing executive action, renewed travel restrictions, changes to visa processing, everything from corporate mobility to cross-border restructuring are being impacted. In this 1-hour webinar, we'll break down what's changed so far and what it means for employers, sponsors, and globally mobile individuals. We'll cover key developments in US immigration policy, review the ripple effects on UK and Canadian frameworks, highlight changes in US tax law and employment law, and explore what could be next for business planning, compliance, and talent strategy. We'd like for you to please type in your questions to the chat box to the full lineup of panelists rather than to individual panelists. And we'll cover your questions at the very end of the webinar. We've left plenty of room for that. And also please note that this webinar will be recorded. And once again, thank you for joining us. We have here the list of topics that we'll be covering in the order we're covering them. And we'll start out with US immigration update for you today. So today I'll walk you through what US immigration looks like under Trump, under the Trump administration, often referred to as Trump 2.0. We'll cover executive actions, visa processing updates, impacts on business immigration, and I-9 compliance risks, and importantly, how companies still can protect themselves and their employees. So what we have here is I'd like to start out by showing you a running list of the actions taken by the administration in the last 100 days. And this covers several slides, sort of like 6 slides or so. And it's clear that since returning to the national spotlight, the Trump 2.0 movement is focusing its attention on US immigration policy, making it a central pillar of its economic agenda and political agenda. So if you could just move through these various slides, you'll see this is from day one, moving on through the present time. So there's been a barrage of policy changes, reported in the news, and there's no signs of that letting up. So moving on to executive orders and policy shifts affecting US immigration. So I'd like to just start out with the big picture. Since returning to office, President Trump really has wasted no time in reintroducing many of the policies we saw during his first term. And without going into a great level of detail on all of these executive orders in the limited time we have, suffice it to say that these orders have tightened eligibility across employment, family, and humanitarian immigration categories. And generally, there's now an American first principle that dominates the scene, meaning that there's more focus on protecting US jobs and tougher scrutiny of foreign workers. And employment-based immigration is being framed more narrowly, favoring really only the highest skilled individuals. So when we're looking at policy shifts, really the bottom line is that companies should expect higher denial rates, longer processing times, and far more requests for evidence, especially for work visas. Thank you. Moving on. So if we talk about the highlights in changes to visa processing, travel bans, and enforcement priorities, starting out with visa interviews and visa processing, what we're seeing is that consular officers are applying much stricter eligibility standards. There's also just generally more refusals, especially those based on sort of this very amorphous immigrant intent refusal. And we're seeing those more common. So there's certainly heightened restrictions, heightened anxiety from those who are going in for visa interviews. And companies should be well aware of that and should be extremely well prepared when sending people in for interviews. In terms of travel bans, there's no clear travel bans the way there was in Trump 1.0, but so there's been a hold on expected travel bans, but it remains a stated policy goal. So we would, suggest that employers anticipate these impacts and prepare in advance as much as possible. Any questions that you've got about or concerns about potential travel bans, should be addressed with your immigration counsel. In terms of enforcement, we know that ICE, which stands for Immigration and Customs Enforcement, has been instructed to ramp up work site enforcement. And we're seeing the return of more frequent workplace raids and unannounced inspections. And you may have been hearing about that in the news as well. So in terms of practical trips, if your employees are traveling internationally, it's far safer to apply for a work visa rather than rely on ESTA. What you may be hearing about in the news is people being denied under ESTA, and even if they're not being denied, their phones might be looked at, social media accounts might be looked at. So for those who may not need to apply for a visa, if employees are traveling under ESTA, it's advisable that, perhaps to simplify things, that they remove social media accounts off of their phone, possibly even, have a burner phone with them. Look at any posts on their laptop or on their phones that might be seen as, contrary to US government policies. And even short business meetings can be misinterpreted and could lead to a denial at the border. And if an employee is denied at the border, they could be allowed to effectively withdraw their application at the border, which is sort of a softer, gentler approach. Or they could face an expedited removal, which potentially could result in a 5-year ban from entry into the United States. So being prepared for ESTA travel is extremely important. Being prepared for visa interviews as well is extremely important. Moving on to business immigration impacts based on visa category. So if we look at the various visa categories that companies commonly use to send employees, looking at the H-1B category, and the category still exists, the regulations are still remain the same, but adjudications are tougher, and there's a heavier focus on proving that the role is truly a specialty occupation. Now, that's nothing new. We've seen that in the past with USCIS caseworkers sending requests for further evidence about proving that the role is a specialty occupation, but it just seems to be even more heightened standards than ever before. They're also going to be looking at third-party placement arrangements. That's also under scrutiny. And what third-party placement means is that if a U.S. company brings a foreign worker to the U.S. under H-1B category, but then places that employee on a client work site, that arrangement is going to be heavily scrutinized because the H-1B rules require that the company sponsoring that H-1B individual have control over that individual's daily work. And so there has to be a true employer-employee relationship. So that will be under heavier scrutiny. Looking at the L1 category, the L1 is the intercompany transfer category. We're going to probably see more specialized knowledge applications under heavier scrutiny. So that requirement is being narrowly interpreted. And you have to really look closely at, does that individual have knowledge that's unique in the industry that can't be easily found in the United States. Now, if you've got an L1 manager, you have to look closely at how many people are they managing, or do they have an extremely important senior function within the organization? Or, if they're C-suite level employees, then you have to document that very carefully. In terms of green cards, the PERM process is facing longer audits. So the PERM process is the process whereby a company first has to test the labor market before they can actually sponsor an employee for a green card. So they have to put advertising out in an attempt, ideally, to recruit a US citizen. Now, that is a Department of Labor controlled process, and the Department of Labor can choose to audit the company's review process or interviewing process, recruitment process. And that process can take a significant amount of time and can create significant delays. You want to leave, it could delay things by even as much as a year in the entire process. And there's certainly pressure overall to prioritize US workers even more aggressively. So if companies are pursuing green cards, again, general rule of thumb will be to over document and to really not leave any stone unturned in proving that this individual is crucial, essential to your US operation. Now, some might think it's doom and gloom for companies and employees looking to transfer to the US. I mean, what path still exists? Really, all these paths still exist. All these visa routes still exist, especially for top tier talent. But generally, just the level of scrutiny is going to be higher. And just a practice tip: if you think an employee may qualify for a visa, you want to file as early as you can with even more supporting documentation than you may think is needed, because then applications won't survive the Trump 2.0 review. And so we're probably likely to see more requests for further evidence for petitions filed with US Citizenship and Immigration Service. And even at the embassy level, we are going to continue to see a higher level of scrutiny. So it's more important than ever for clients and companies and employees to be extremely well prepared and to know what to expect at the embassy interview stage, and be prepared for what may happen at the border, and be knowledgeable about what their rights are at the border as well. Last thing I want to talk about is I-9 compliance. So, companies in the US have employees that they bring to the US, but they have to do right to work checks. And right now we're seeing that worksite audits have surged, and the Immigration and Customs Enforcement is actively targeting industries known for sponsoring foreign workers. So companies on the ground have to be aware that even if they can get an employee into the US, they have to be diligent in completing their I-9 right to work documentation for foreign workers. So what should companies do about that? Do their own internal audit of their I-9s, get a lawyer involved if need be, and make sure that you're fully compliant with I-9 rules. And even paperwork errors can lead to fines and violations that could result in criminal penalties. So it's a more challenging time in U.S. immigration, but the pathways still remain available for companies who are willing to put the time and effort into getting the appropriate visas. Thank you. I'll pass it on to my colleague Naomi to give us an overview of UK immigration law as it stands today.
Thank you so much, and thank you for inviting us and organising it as well. First, I should say the direct change to UK immigration policy and law is insignificant in that they haven't changed anything. I know there are some people that almost feel like there should be some refugee laws being instigated to allow some easier ways into the country, but there are nothing like that in the UK. There are no special privileges for American nationals. They're not Commonwealth nationals who have access to the ancestry visa, for example. And they're not currently in the discussions where the Home Office are talking to the EEA group to see whether or not youth mobility will be expanded to European nationals. That's an excellent move, one that's long overdue and does appear to be on the go. It could get extended to American nationals in the future, but it's not as yet on the table. What we instead have is forcing people into the existing routes, which is primarily sponsored worker routes and global talent for anybody who's seeking to move to the UK that doesn't already have a family route to the UK. That's a huge reduction from what we had 5, 10 years ago. There's no specific high net worth individual category anymore. And indeed, a lot of people that would have used categories like the investor visa and the entrepreneur visa in the past have had to wedge themselves into the sponsorship route. And the Home Office will often call that self-sponsorship, where they will use their own UK company to sponsor them. And the Home Office don't really love that scenario. It's something they say they're cracking down on. It can be done legitimately, but it's one to be wary of and to always be done with a lot of expert assistance. So what we see at the moment are changes to the UK immigration system that are affecting everyone, and how those impact perhaps slightly differently on US nationals given the current climate. I do find myself having some increased conversations with particularly high net worth American nationals who are looking to find an option for the UK, even if they're not actually saying that they definitely want to move to the UK, they're just wanting to have an option just in case. So, for example, I was speaking to the head and founder of a huge US tech company recently, who is himself British. His wife, however, is American, and he just wanted to get her a spouse visa, even though they weren't going to move here yet. Similarly, we had some celebrities who had found out that they had some tenuous links to Ireland. We have an Irish immigration practice as well. We were looking at Irish citizenship for them, Italian citizenship for people where they thought that might still assist as well. So there's a lot of that, looking for other potentials and possibilities. The UK government have a white paper at the moment that is sort of being researched and soon to be published. We're expecting that to look at clamping down even further on illegal working in particular. They have announced very clearly that they intend to ensure companies check the right to work for not just employees anymore. They will also be for workers and self-employed persons. That is something that has been signaled for a long time. In particular, it's being aimed at sort of recruitment agencies, construction industry, gig economy, because they deem that to be very high risk for illegal working. We are seeing a huge amount of crackdown on compliance within illegal working. I mean, huge. In my entire career, I have not seen more of that. So this afternoon, I have a response on one, submitted one yesterday. My colleague submitted 2 in the last few days, because the Home Office are picking up on illegal working a lot better than they ever have in the past, in large part through data sharing with HMRC on payments, and the tax rule IR35, which requires employers to be paying taxes via HMRC for people even where they're not an employee directly, has meant that a lot more people are being detected that way. And then there is often some confusion, I think, around whether or not illegal working penalties apply to them, because strictly speaking, it shouldn't apply to self-employed persons, or it shouldn't apply to the company that they are doing work for on a self-employed basis, at least for the time being, until the white paper is published and the laws are passed to change that. That then means that you need some really quite expertise, niche advice to reply to the Home Office on the basis of the employment grounds. And that's something I've done a lot of times, because we obviously have an excellent employment law practice, and we have a couple of people in our team that have qualified in both employment and immigration simultaneously. And normally you will get a response back relatively quickly, begrudgingly accepting that argument. But now I think the Home Office are trying their luck a bit more and pushing back on those. So sometimes we may need to instruct to go to tribunal before they will back down. So I think US companies, as much as any other company, needs to really focus on that more than anything else. There are a lot of tech companies out of the US who rely on that kind of structure. So then we have The annual increases in immigration fees makes it more expensive for people who are looking to come to the UK from the US or anywhere else. We have the introduction of the ETA, or Electronic Travel Authorization Scheme. It's essentially the UK's version of ESTA to the US, and that's having a huge impact on visitors. And a lot of those will be American nationals. We've certainly done a lot of work for them ourselves, whereby typically somebody like an American national or a Canadian or an Australian, we call those a non-visa national. They don't need to apply in advance for a visa. So they've been used to coming in and out of the UK via e-gates a lot of the time with their passport and not thinking about either what activities they've done or what their criminal history might be. So a lot of people might have had possession of cannabis from 10 years ago, or we did something for a famous musician recently who had a jail term of 12 months that was almost 20 years ago now and had in fact been deferred part of it. But those things now will automatically lead to refusal of the ETA, and then you need to make much more substantial representations in the form of a formal visitor visa application. So where somebody 9 times out of 10 hasn't even thought about it in advance of travel, they've just put in that ETA application, had a bounce back for a refusal. They might have been doing that the night before they were intending to travel. If you are a musician, for example, booked on a tour, that can be hugely detrimental to your plans. So we're trying to make sure that the awareness of that is increasing as well. I think generally people are getting good at that, but it's also something where I had a Canadian national recently who just didn't read the question properly, answered yes, that he'd had an offence within the last 12 months. In fact, it was 10 years ago. So exactly the same issue then, and it becomes much harder to correct. So it's something to be really a lot more wary of than you might think, given it is predominantly an administrative process for the majority of people. So we do see that slight increase in the number of inquiries for long-term relocation from the US. There's no change to the application process or the documentary requirements, but do be wary that processing times typically always increase over the summer, and may do even more than usual, where we have an increase in applications, not just from the usual influx of student visas in time for the new school year, but also perhaps from people who, I would say, it may not be at all political reasons, it may be the economic reasons. I was talking to an investment banker yesterday who was saying that apparently there has been no more negative impact on the economy since Nixon came to power for the first 100 days. So what we often see when you're looking at the advanced nations around the world is we're not moving because we're refugees, we're moving because of economic motivations or school motivations. And that may actually have a bigger impact than simply who was recently elected and what their policies might be. The other thing that we see, which I'm only going to sort of headline, because I think that will be talked about later on by our UK employment law expert, because what these are is individuals who are refusing to go to the US because they're concerned about being turned away. We do see that with a little bit more frequently. Also, they might have personal objections to it. And then you have more of an employment law question around what you do in that situation if you did really want them to go there. DE&I has been affected significantly, ESG has been affected significantly. And again, I'll leave that for my colleague later, but I have a lot of conversations with HRDs based in the UK who are part of US companies, and they're finding the tensions between the two cultures and how to manage HR policies across the global workforce where US policies have changed is a really significant issue for them on a day-to-day basis. Finally, in terms of potential long-term trends and Brexit-related factors, well, the biggest impact of Brexit, of course, is that more people are coming from outside of the EU instead of from the EU. That is as far afield as the US, but also much further as well. And it depends on which part of the workforce you're talking about. So from the lower skilled sections of the workforce, like care workers, we have a lot of people coming from Nigeria and India instead of the EEA. But from your highly skilled professional workforce, the US is obviously one of the key utilizers of that route. And the white paper that the Home Office are sort of keeping on our horizon is indicating that they're expecting to see a continued reduction. We say continued reduction, a continued aim to reduce work-related migration to the UK, and what instead happens is we continue to have an increase in it. They just make it harder and more expensive and more bureaucratic for people. So we're not expecting any significant changes to the lower skilled routes, but those more highly skilled routes, I think, will continue to become more and more expensive. global talent then becomes more and more valuable as well. That is, I think, all that we need to highlight there. Give us a call if you would like to find out more.
Great. Thank you so much, Naomi. Lots of interesting developments in UK immigration. Thanks for sharing that with us. I'd like to pass things over to our Canadian immigration law expert, Pavan Dillon, who will share immigration considerations in Canada. A lot happening in Canada, and I'm sure you feel impacts even more than we do maybe in the UK because of your proximity to the US. So we'd love to hear your thoughts, Pavan.
Great, thank you very much. It's a pleasure to join you today, and thank you to everyone for logging in. So Canada has been a close friend and partner of the United States, but not the 51st state, and has been a natural option for many US residents and companies seeking to retain talent through the ups and downs of US immigration policy. But in fact, after the first Trump election, after the first time Trump was elected in November 2016, the Canadian immigration website crashed from overwhelming interest. My practice is unique in that our firm practices exclusively Canadian immigration from the United States. I'm based in Seattle, Washington, and many of our consultations recently leading up to Trump assuming power for the second time, as well as within the first 100 days, have really been in reaction to the current Trump presidency, current Trump policies, including immigration, as Nita has already discussed. Canada offers predictability, economic stability, and is a cultural mosaic, and partly based on its welcoming immigration policies. I'd like to focus on how Canada's immigration system is evolving under Prime Minister Mark Carney, who was recently elected as Canada's Prime Minister and has been in power for 47 days. Next slide, please. Canada, the sentiment around immigration recently has shifted in Canada as well, primarily not because of US policies, but because of Canada's own reforms to address domestic pressures. Essentially, from 2020 to 2024, we saw a rapid influx of temporary residents. Canada's population grew by 1.27 million, which is the fastest pace since 1957. Keeping in mind that Canada's population is a little over 40 million, significant amount of growth. The temporary residents now account for over 7% of the population, and this has led to housing crisis as well as pressures on social services. So there was a large influx of immigration, but the policies around and the infrastructure was not particularly built to handle it. And what this led to is a shift in public sentiment, as well as a shift in government policies towards immigration. Next slide, please. And essentially this change has occurred over the past 6 months or so. Changes have occurred over the past 6 months under Prime Minister Justin Trudeau, and now under Prime Minister Mark Carney. We're expecting much of the same. That was the policy, that was the campaign that they ran on. But essentially, we've seen temporary residents will now be capped at 5% of the population, and permanent residents will be decreasing by about 20%. This isn't necessarily shutting the doors on immigration. It is really narrowing them, though. Next slide, please. Oh, and essentially sorry, if you could go back 2 slides. And what we are seeing now is a revitalization of priorities and strategic priorities and categories, but also most permanent residence programs are now going to require Canadian experience. And that's a big shift for companies. So companies now need to be aware of the fact that most individuals are going to need a work permit first and Canadian experience, but also individuals within Canada are going to need extensions. And that is essentially the primary shift that's been taking place. Next slide, please. I wanted to just cover some of the top options. Canada has over 40 work permit application categories, as well as 80 permanent residence categories. We don't have enough time to go through all of them, but I did want to touch upon the most common. To understand the work permit options, there are two major work permit programs. The first it requires a test of the Canadian labor market, and this is for the work permit stage. And this includes advertising or a benefits plan. The second is the faster approach and the one that we look to first, which is called the International Mobility Program. Next slide, please. And next slide, thank you. I'm going to just touch upon the free trade agreements first. Canada has a free trade agreement with the United States. Canada calls it CUSMA, the US calls it USMCA. But the main category that falls under this is the FTA professionals. But Canada also has free trade agreements with the UK, EU, several Asian countries, and South American countries. The professional category is one of our favorites. It looks at citizenship of the individual, the education class background or experience in some categories, and does require a job offer in that category for an applicant to be approved. And it's very similar to the US TN visa. We also have intercompany transfers, very similar to the L1A and the L1B, which allow multinational corporations to bring in a specialized knowledge worker or a senior manager and executive into Canada for a specific period of time to transfer that knowledge. The main difference is that specialized knowledge now requires 2 years of proprietary or company-specific information and expertise to be transferred to the Canadian entity. Next slide, please. I also wanted to touch upon the Francophone Mobility Program, as it's a unique one for Canada. Canada is really focused on increasing Francophone migration to provinces other than Quebec. In fact, Mark Carney ran on increasing the percentage to 12% in the coming year. Thus, coming years. And so this is a relatively newer program that requires only a low intermediate level of French, and is a great program for high-skilled or semi-skilled applicants who are seeking to come to Canada. And this threshold is only low intermediate. So we've had individuals in the last 2 years or year learn enough French in order to qualify, to give you an idea. So it's a popular program. This one also requires a job offer from a Canadian company. And the last one, the Youth Mobility, Canada has over 40 bilateral agreements that allow individuals who are under 35 or 30, depending on the country, to work in Canada. Some of them do not require a work permit. Very popular program in the UK, for instance, and also in the United States, which is eligible for this category as well. Next slide, please. I wanted to also touch upon the Global Talent Stream. This is a category that requires a labor market impact assessment. So even though it is one of the more popular categories, it is actually not the first one that we look at. Next slide, please. It is instead for individuals who don't qualify for the International Mobility Program work permits that we just discussed. We use this often for instance, software engineers from China or India who need to enter Canada. It's a very fast processing period for the first stage. It's 10 business days, and then depending on the citizenship, they can apply for a work permit. Either at the port of entry or through the consulate. The main difference between this is that there is no advertising. There is a STEM talent list. So if the occupation falls on that list, the company does not need to advertise, but they do need to provide a benefit to Canada. And that benefit is a formal agreement with the company and the Canadian government, confirming that they will hire Canadians, they will provide benefits to their local labor force, as well as the local economy. And that is the basis of the work permit, very unique to Canadian immigration, and a fast track popular option for those who don't fall under one of the categories we previously discussed. Lastly, next slide, please. And the next slide as well. I'm going to just touch upon Express Entry, which is Canada's flagship permanent residence program. Once an applicant has that Canadian experience, we generally will look at this as a way to keep them permanently in Canada. The main benefit is that it's very fast processing, 4 to 6 months to become a Canadian permanent resident. Traditionally a huge draw for many of our US-based applicants. And that was primarily the presentation that I wanted to share today. I realized that Trump's policies have heightened interest in Canada, but primarily the reforms really address domestic pressures. And ultimately, Canada's doors are still open, but the rules are changing. And for US businesses and for professionals, success is really going to depend on preparation in advance, documentation strategy, and a clear understanding of a temporary first entry through the work permit process. Thank you.
Great. So my name is Chris McLemore. I'm a London-based US tax lawyer. We provide all manner of private client tax, from income tax to estate, gift tax planning, trust planning, and beyond. And Nita asked me to talk about what's happened in the first 100 days from a US tax perspective. The reality is not much yet, but we might be on the cusp of some significant changes. So if we cast our minds back to President Trump's first time in office, in 2017, he passed the Tax Cut and Jobs Act in 2017, which was viewed as a significant and material tax cut across a range of categories and a range of types of income. Now, for various reasons, the vast majority, if not all of those cuts and provisions are due to expire at the end of this year. So from January 1, 2026, we effectively revert back to the pre-2017 Tax Act. So when Trump was on the campaign trail, to the extent he got involved in tax policy, his primary focus was talking about the extension of those cuts. Now, just yesterday, President Trump announced that he wants the tax bill to be passed by the 4th of July. So it's not actually been introduced to either House of Congress yet. I understand that in the House of Representatives, a piece of legislation will be put forward soon, and the goal is to get that passed in both houses by the 4th of July. Now, if you recall, Republicans control both the House and the Senate, but the majority is very slim. So in the House of Representatives, I think it's a 220 to 213 vote lead, and in the Senate, it's 53 to 47 Democrats. Now, that's really important because in traditional cases, unless you have 60 votes in the Senate, it's possible for the minority party to filibuster and prevent legislation from passing. But when it comes to certain tax and budget bills, there's a process known as reconciliation, where you can effectively get bills pushed through without having to worry about a Senate filibuster. And that's how the 2017 Tax Act was put through, because again, there was not a 60-vote supermajority in the Senate. The problem that comes about with the reconciliation process is that there are more narrow parameters in terms of how you get things put forward or passed through. One of the limitations is that you effectively have to reduce the amount of additional debt that you add through what is viewed as additional spending. And so although it's not viewed as such, naturally a tax cut is effectively an increase in spending because it actually has an economic or a financial cost. So these limitations with respect to how much can be added is going to be a real barrier that we're going to be watching as to whether or not the reconciliation process will be successful. Donald Trump himself is putting a lot of pressure on the House members, the Republican House members. As I mentioned, it's a 220 to 213 vote advantage for the Republicans. But there are a number of Republicans who are significantly concerned about the effect on the US deficit. President Trump has identified a number of what he calls renegades who may be looking to side with the Democrats and create some problems. So there is a lot of work to be done. But Republican lawmakers at the moment are at least projecting that they think that they can get this over the line. In addition to the changes that happened in 2017, the other priority for President Trump is eliminating income tax on tips, on Social Security, and on overtime payments. Again, that's going to be another difficult sell because of the potential effect on the deficit. Now, if the Tax Act of 2017 is not extended and is allowed to expire, one of the really significant effects of that, at least for our client base, would be a reduction in the U.S. federal estate and gift tax exemption. So one of the big changes in 2017 was that Americans who are subject to federal gift and estate tax, just like they are federal income tax on a worldwide basis, and no matter where you live, you've got a federal estate tax bill that follows you. The exemption was increased significantly, and today the exemption per person stands at $13.99 million, which means that a married couple of 2 American citizens can pass effectively $28 million on death or during lifetime without a federal gift or estate tax charge. Now, if this tax bill isn't passed or they're not able to get the votes with respect to the estate tax provisions, those numbers, that exemption will reduce to 5 million plus an inflation adjustment. So going from 28 million to 10 million plus inflation. Now, that's still a significant amount. It covers many, many, many estates of US citizens, but that will be something that we'll need to keep an eye on if the legislation isn't passed or there's some concerns about their ability to extend the estate tax allowance. Then we'll be talking to clients about making sure that if they have the means to do so, they take advantage of the inflated number now, because once it goes back to 5 million from January 1st of next year, it's gone. So it's effectively a use it or lose it type situation. Now, something that was being discussed both during the election and also early days of Trump's presidency, but we haven't seen much movement on, is a change to the citizenship-based taxation, which is the kind of foundation of American taxation. So as I mentioned before, Americans are subject to federal income tax no matter where they live, and that's unique almost in the world. Virtually no other country bases income taxation exclusively on citizenship. It's almost always based on residence and situs. And so this has been a big issue. And actually, you have Americans who live abroad from across the spectrum, Republicans, Democrats, Independents, who have been campaigning to get something done on citizenship-based taxation. And legislation was introduced by a Republican congressman in Illinois, Representative LaHood, which would eliminate CBT. And in the waning days of the campaign, President Trump said this is something he was definitely going to do, that it has his attention, he was going to ensure it got passed. But in the most recent discussions around the tax legislation, we didn't see anything on CBT popping up. The way that the rules would work, the draft legislation would work, is that if you're born outside of America, you're automatically a non-resident for income tax purposes. So now, if you've got clients who are either US citizens who have children abroad who receive US citizenship, or maybe they're temporarily in the US and they have a child who's a US citizen, that child is going to be a US citizen or a US taxpayer unless they can renounce their citizenship at some point, which is generally after age 18. And the new rules, if you were born outside the United States, you automatically start as a non-resident. Otherwise, an individual US citizen like myself could make an election to become treated as a non-resident alien. If I make that election, I'm only subject to US income tax on my US source income. So that's things like compensation income in the US, pension distributions from US pensions, rental income. If I have a house in the US, I've gone abroad for a period and I rent it out. Those types of things, which would be taxable in the hands of most non-Americans anyway. The rules require that you have to be outside of the US for at least 3 years. So if you move out, you make this election and you go back within 3 years, there is a clawback provision. So that's potentially a trap for the unwary. If an individual doesn't know how long they'll be outside the US, maybe they don't make the election pending some type of clawback. It doesn't affect state tax. So you might continue to be exposed to US state income tax. If you have connections to certain states, they wouldn't be affected by this bill. The bill also doesn't affect, as drafted, estate tax. So again, you can become a non-US person for purposes of income tax and still be exposed to estate tax. And then the final consideration is that you have to be under the estate tax exemption amount in order to make this election. So as I said a moment ago, the estate tax allowance at the moment is $13.99 million, potentially going down to $5 million. If your net worth is over that amount, you can't elect out. So again, that's not going to cover a large ratio of Americans living abroad, but for those who would be particularly minded to make this election, that's going to be something that might be causing them to remain in the US tax net. Finally, I would say that from a UK perspective, the UK still remains a uniquely appealing place for Americans. There are significant changes both to income tax and inheritance tax that came about from 6 April. And you've probably seen in the paper that there are a lot of wealthy individuals who are leaving the UK. For Americans who are already exposed to income tax on a worldwide basis, the changes to income tax in the UK are probably not that big of a concern for most. The bigger consideration would be exposure to inheritance tax, but you've got a 10-year window until you now become exposed to income tax or inheritance tax in this country. So that gives Americans time to come over, get their feet wet, experience, life abroad. If they decide to stay, there's some opportunities for planning that are unique to Americans because of the way the US-UK income tax treaty is drafted. So notwithstanding the fact that here in the UK, there have been some significant changes for Americans, either because they want to move because of the political climate or just because of the robust relationship between the two countries, that opportunity remains appealing. And if there is, by some surprise, a change to citizenship-based taxation, perhaps an even more appealing outcome.
Great. Thank you so much, Chris, for your insights. Really interesting, and we'll certainly watch that space. Never a dull moment. US tax. We'd love to pass it over to Michelle, who will give us her insights on employment law.
Thank you, Nita. Thanks for having me today. As Nita alluded to briefly, I'm a U.S. employment lawyer. I live and work here in the U.K., and our practice is to advise companies who have employees both in the U.K. and in the U.S. about the different laws between the two and how you can try to reconcile and comply appropriately depending on where your workforce is located. Next slide, please. So much of the attention that President Trump has received concerning employment changes surrounds his action with respect to DEI. Naomi alluded to this earlier. DEI, which stands for diversity, equity, and inclusion, has been his focus in many of his executive orders. We'll see on subsequent slides that not many of these orders actually have a direct impact on the UK, but they certainly influence cultural expectations and might influence a company that has both US and UK employees. So I'm going to summarize briefly what those changes are in the US, and then we'll talk about how they impact employers here in the UK. So to summarize the changes, possibly the most impactful, and this was really a big deal if you're a federal contractor, was President Trump's rescission of a very long-standing executive order. It's called Executive Order 11246. It rescinded an executive order that dates to the civil rights era that has been in place since President Johnson. President Johnson was the president who immediately came after President Kennedy. So it's been around for a very long time. And under this previous executive order, any company that was signing a contract with the federal government to provide certain services, they're known as federal contractors, had to establish an affirmative action plan. It was a relatively onerous process to demonstrate that the company was taking action to increase the diversity of its workforce. President Trump's executive order has rescinded that obligation, so federal contractors moving forward do not need to establish affirmative action plans. Instead, federal contractors and also recipients of federal grants will likely have to certify on their application that they do not operate any DEI programs that violate federal anti-immigration laws. So that's a sea change in the federal contractor space. The rest of President Trump's executive orders really are not a sea change. They seem like it because of the language that he uses, but in actual fact, he has not changed the law. He has instead directed enforcement action towards certain components of DEI programs. So in various of these executive orders, he's directed various federal agencies to establish an enforcement plan to root out, locate, and then address any unlawful DEI programs. The Equal Employment Opportunities Commission, which is the federal agency responsible for enforcing the US's anti-discrimination laws, issued their own guidance clarifying which features of DEI programs they believe are unlawful. And that guidance targets a lot of the hallmarks of DEI programs that a lot of larger companies were using. So according to the EEOC, it believes that it may violate federal anti-discrimination laws if you exclude or allow access to training, mentoring, network, employee resource groups, any of those types of programs on the basis of any sort of protected characteristic. The EEOC also believes that it may violate anti-discrimination laws to establish diversity quotas or balanced candidate slates, these types of programs that companies were using in order to increase diversity, the EEOC believes may now be unlawful. However, none of this actually is a change to the law. So it has been unlawful in the United States for a very long time to make any sort of employment decision on the basis of a protected characteristic. That was the law, it is still the law as applied to private companies, and that hasn't changed. What has changed is the enforcement priority, and I think the cultural expectation surrounding what is an appropriate DEI program and what will be tolerated. You'll have seen, no doubt, in the news, a lot of high-profile companies are retreating from some of their more publicly focused DEI efforts. There'll be a trickle-down impact, certainly, even with the less high-profile companies. They're doing so for a multitude of reasons, including perhaps the concern that they'll be targeted with one of these enforcement efforts. And so given these changes, even though the law hasn't changed, definitely we're seeing a practical impact. Next slide, please. So what does it mean for companies in the UK who have a UK-based workforce? So the good news for UK companies, as far as simplicity, is that very few US laws have any sort of extraterritorial application. So most US employment laws do not apply overseas. There are some limited exceptions, and I've got them here on the slide for you, for certain laws which could apply under certain very discrete circumstances. So some of the anti-discrimination laws apply and protect US citizens who are working for a US employer or who are working for a foreign company that's controlled by a US employer overseas. Others just don't apply at all. And typically there is a defense if you cannot comply with the US law without violating the foreign national law. Next slide, please. So these DEI pronouncements from the Trump administration, for the most part, are not going to apply in the UK. The UK already has its own DEI sort of laws, so to speak. It has a framework of employment laws here that give direction to UK companies for how to comply with UK employment laws. There's a notion here called positive action. It's not really the same as affirmative action. It's quite limited. That remains the law in the UK, and the changes to affirmative action in the US don't technically impact companies here. There is an importance here of continuing to train your workforce, even if in the US we may be seeing a retreat from some diversity training. Here in the UK, there's an obligation to take all reasonable steps to prevent sexual harassment, which could certainly include training. And soon there will be liability for third-party harassment. You can help protect against that liability, often by providing training to your workforce. So UK laws will apply here, and they differ from the laws in the US. However, of course, as often is the case, US culture is powerful and can infiltrate borders. And it certainly, I think, could well be true that we'll see some retreat from DEI efforts here in the UK, even if legally there's no obligation to retreat. Next slide, please. Okay, in the UK, instead of seeing these retreats, what we are instead seeing is the current government's proposed changes to the Employment Rights Bill. I'm not going to go through these. That's not really the focus of today's program, but you can see on the screen there are a number of changes that we anticipate will come in place, possibly in the autumn, and most of those changes are largely more protective of employee rights. It illustrates a divergence in priorities between the current UK government and the Trump administration. And so companies in the UK, even if they have connection to companies in the US, need to be prepared for these incoming laws, which will differ from their obligations in the US. Next slide, please. So what do we think will happen with multinational companies and where they recruit? Honestly, I don't know, all of us can predict where we think the future will go, and we'll probably all be slightly wrong. When Trump was first elected, we saw a lot of optimism about the US market, and our practice in particular works with a lot of companies that are trying to expand in the US market. A lot of optimism about business opportunity and market predictions of growth in the US. Of course, that has potentially changed with the announcement of tariffs. So unclear whether multinational companies will perceive hiring in the US to be more appealing than hiring in the UK or less appealing. In addition, I think Nita was mentioning this earlier, or perhaps it was Naomi, that you'll have to be prepared with where and how you can get your employees the right to work. And so if it's going to be more difficult to get employees into the US, perhaps that might lead to more sort of local hiring and vice versa. In the US, one of the impacts of the first 100 days of President Trump has been that there has been a decrease of access to federal money given to companies, such as access to federal grants. This impacts very specific industries, particularly. So life sciences, for example, who gets a lot of research funding from federal offices, has had less access to that funding. That could result in less hiring in the US, but of course, none of us really know. So it remains to be seen, I think, where multinational companies will believe that they have where they want to focus their employment-specific growth. Next slide, please. So what should you do in the UK? So if you have a company with UK-based employees, even if you also have some sort of connection to the US, the thing I want you to leave with is the idea that you have to comply with UK law. So US laws largely will not apply to your UK operations, at least with respect to employment. UK laws are the ones that will primarily apply, and those differ. So your policies as applied to the UK workforce will likely need to differ from US policies. Often companies with cross-border employees prefer to have one policy to apply to their whole workforce, which makes perfect operational sense. It doesn't always work. And this may be one of those situations with the diverging laws where you'll have to look at those policies and reconcile where you can, possibly have separate policies where you can't. You should be focused on talking to your employees who express concerns. So we've had questions in our office from companies who are sending employees to the States, and those UK companies, the UK employees rather, are expressing concern, including related to harassment, let's say on the basis of transgender identity, concern, of course, related to the border. So talking to your employees, understanding their concern, and then making an informed decision about how you want to proceed is, of course, important. And then also you'll need to be prepared to navigate your US stakeholders and any pressure they may put on your UK workforce to align culture over here with the policies in the US. Sometimes you can align them, and there may be a good reason to. Other times you cannot align them without violating UK law. And so that's a conversation you'll have to have with your US stakeholders. And that's it for me, Nita. Thank you.
Great. Thank you so much, Michelle. That was incredibly interesting. And thank you to all the panelists. We have a very limited time here just to see if there are any questions, but I don't see any in the chat. But if anyone has any questions specific to any of our expert panelists, please feel free to reach out to them directly, or if you want their contact details, you can reach me as well. But I'd like to end and just having some key takeaways or some key tips or just the summary from each of you on for businesses and individuals. Maybe I'll start out from U.S. immigration. I would say some of the key tips would be, if you send staff to the U.S. under ESTA, you want to be prepared with a letter explaining location, time, and the details and the dates of the meeting, and even print out return ticket and carry evidence of UK or foreign employment. I would suggest also taking social media apps off of your phone, using a burner phone, doing anything you can to simplify the process of getting into the US. Another tip could be potentially to travel through Dublin pre-clearance if you're traveling from the EU. Dublin allows you to clear US immigration before you board the flight. So if anyone has any serious concerns about travel, or just very nervous and worried about what could happen, they could attempt to travel through Dublin. If they're denied, at least they're not going to be detained, and they'll just be sent back home. Another tip is that if Customs and Border Protection denies someone, you want to ask for a withdrawal of admission. So ask as many questions, that employee should ask as many questions as possible about what is their position at the time of being denied entry. Are they being allowed to withdraw their admission, or is this an expedited removal situation, which is much more serious? The final tip is for staff with actual visas, they should carry copies of their approval notices. And I would suggest even having a full copy of their petition with them, or at least on their phone, so that they can present that if needed. So be well documented. Could I just move on to Naomi for any final tips that you have?
Sorry, just unmuting myself there.
Yeah.
I think planning ahead and making sure, particularly with the ETA, that traveling to the UK has been thought of in advance, because you never know if somebody has some kind of misdemeanor from their youth that they haven't thought about in a long time, but that can actually create a problem now where it wouldn't have before. Not unique necessarily to Trump's administration, but something that is catching a lot of American nationals out at the moment.
Thank you, Naomi.
Thank you.
Thank you. And Pavan, you have any final tips or takeaways?
Yes, definitely. I think one of the key areas to be aware of is just the flux in immigration at the moment. So something that you may have understood from prior applications may not be the same currently, and it's important to be up to date about Canadian immigration regulations and to plan ahead, as we are seeing processing delays, particularly within Canada for extensions, but also for outside the country.
Thank you, Pavan. And Chris, do you have any final tips or takeaways?
Yeah, I mean, it's really just a matter of watch this space. We expect that the Trump Tax Act will pass. But if it's not, and the tariffs are certainly slightly disrupting matters at the moment. They were expecting that the tariffs would raise additional revenue, which would help get some of these provisions through more easily. So, for instance, if there are some provisions that they can't pay for and aren't extended, just need to pay attention to those, especially things like estate tax. So that would be the takeaway. We think things will proceed as normal, but this is not a normal situation. So just bear that in mind.
Thank you, Chris. And Michelle.
Yeah, I think the biggest tip from an employment perspective is to be mindful of your local obligations. So typically for employment law, the laws where the employees sit will likely apply. And so you may be treating your UK workforce slightly differently than you treat your US workforce. In addition to paying attention to the local laws, you should be paying attention to culture and to what your employees are expecting and what you're hearing from them. And I think that should help manage what is clearly a bit of a chaotic and unprecedented time.
Great. Well, thank you so much to our esteemed panel of experts, and thank you all for joining us. If you'd like a recording, please contact us. And if you'd like to reach out directly for help to any one of our panelists, please feel free to reach out to them directly or contact us and we can get you in touch with them. Thanks everyone for joining us today. Have a great day.